If you file a sibling petition today, there's a very real chance your brother or sister won't legally arrive in the United States until the 2040s. Not because you did anything wrong, not because they're unqualified, but because the system is engineered to move siblings last, under a quota that was designed decades ago to be politically survivable, not humanely functional. And if you're a U.S. citizen watching this right now, you're probably making one of two mistakes. Either you're waiting to file because you think you need to get everything perfect and you're burning years you can never get back, or you filed, got the receipt, felt relief, then stopped paying attention, not realizing the receipt is not progress. It's a ticket into a line so long it becomes a lifetime event. Stay with me, because in about 3 minutes, I'm going to expose the single biggest myth that destroys families in the F4 category. The belief that I-130 approval means your sibling is almost here. That myth costs people a decade, and later, I'll reveal a little-known legal lever that can, in some cases, reduce a 20-year wait without bribery, without fraud, and without knowing someone. Most channels won't tell you about it because it's technical and it doesn't fit on a thumbnail, but it's real, and for the right family, it's the difference between 2046 and 2029. This is Immigration News Desk, and today we're not doing motivational talk, we're doing triage, because sibling sponsorship is where the U.S. immigration system is most brutally honest about what it values: spouses, minor children, and parents of citizens first, and siblings as a distant, quota-capped afterthought. Let's ground this in the numbers being discussed right now, February 2026. The wait times people are seeing for the sibling category are staggering, roughly 95 months on the low end to 173 months on the high end, depending on variables. That's about 8 years to over 14 years, before you even start talking about the countries where per-country limits and demand turn the backlog into a 2-decade marathon. And if you or your sibling were born in Mexico, the Philippines, India, or China, you need to brace yourself. Those are the 4 countries that historically collide hardest with per-country caps and high demand. In those cases, sibling waits can stretch into the 20 to 22-year range in real-world projections based on visa bulletin movement patterns. That means if you file today, you could be looking at the year 2046 before your sibling is eligible to receive an immigrant visa. 20 years is not an abstract number. It's the difference between your sibling arriving while your parents are alive or arriving after funerals. It's the difference between your nieces and nephews growing up with you or only knowing you through video calls. It's the difference between shared caregiving and permanent distance. And the cruelty is that the system calls this family reunification. Now here's the first critical revelation you need to understand. F4 is not slow because USCIS is behind. F4 is slow because Congress designed it to be slow. Siblings fall under the 4th family preference category, F4. Unlike immediate relatives of U.S. citizens, spouses, parents, unmarried children under 21, F4 is numerically limited. The global annual allotment is roughly in the neighborhood of 65,000 visas a year for this category, and that number has to cover not just the sibling you're petitioning, but also their spouse and minor children, who often immigrate as derivatives under the same petition. So when you hear 65,000, don't imagine 65,000 individual siblings. Imagine 65,000 total people across entire family units and the entire planet. That is why the line doesn't move like you think it should. Demand is massive, supply is fixed. The result is a structural backlog, and structural backlogs are not accidents. They are political tools. They keep promises alive while keeping numbers controlled. They let politicians say, yes, you can sponsor your sibling, while silently ensuring the majority of families never see it happen quickly enough to matter. This is why I said earlier that the I-130 receipt is not progress. It's a timestamp. It's your priority date, the date USCIS received your petition. That priority date becomes your place in line in a quota system, and the line is governed by the visa bulletin. Here's the myth that destroys families, and I'm going to say it bluntly. An approved I-130 does not mean your sibling can immigrate. It means USCIS agrees the relationship exists and you're eligible to petition. That's it. The real wait begins after approval, because your sibling cannot take the immigrant visa step until the visa bulletin shows your priority date is current. and the Visa Bulletin, for F4, is often working on cases filed more than a decade ago. In February 2026, you're looking at priority dates around 2011 or 2012 for many countries, and much earlier for high-demand countries, sometimes back to 2004 or 2005. Do the math. That's why people who file today are staring at a horizon measured in decades. Now I'm going to open a loop that will matter to you later. There is a reason your category is so exposed to political threats. Sibling sponsorship is one of the first categories lawmakers talk about cutting when they want to reduce family-based immigration numbers without directly attacking spouses and minor children. That means if Congress changes the law, the people who filed early often keep their place through grandfathering rules, while the people who waited lose their chance entirely. I'll come back to this because it's the second biggest mistake U.S. citizens make: procrastination in a category that lawmakers love to target. But before we get into strategy, you need to understand the process you're actually signing up for, because the process itself has booby traps that can add years if you mess up. Step 1 is Form I-130, Petition for Alien Relative. This is where you prove your U.S. citizenship and prove the sibling relationship, sharing at least one common parent. You file with USCIS. You get a receipt notice. Your receipt date becomes your priority date. You wait for USCIS to adjudicate. I-130 processing times can vary wildly by service center and workload. In the numbers you're seeing discussed, people are looking at ranges like 17 months to 60 months, depending on where the case lands and whether USCIS issues an RFE, request for evidence. That means even the first step can be multiple years. Then step 2 begins, and this is where most people psychologically break, waiting for the priority date to become current. This is where you monitor the Visa Bulletin month after month, year after year, watching a date move, sometimes forward, sometimes sideways, sometimes backward in retrogression. During this period, nothing happens to your case externally, and that's why people assume it's dead or that they did something wrong. It's not dead, it's stuck in quota. When the priority date finally becomes current, Step 3 is National Visa Center processing, fees, document submission, civil documents, affidavit of support. Then Step 4 is consular interview abroad, medical exam, police certificates, and final issuance of the immigrant visa. Now, here's a critical point that most people don't understand. Your sibling's life will change over those 20 years, and every change can generate new complications. Marriages, divorces, new children, name changes, military service, prior visa denials, criminal issues, medical issues, everything becomes part of the file. And the U.S. government will evaluate eligibility at the time of visa issuance, not just at the time you filed the petition. That's why set it and forget it is so dangerous. You need to keep the case alive, keep addresses updated, and keep documentation safe for decades. Now let's talk about denials and RFEs, because the F4 I-130 is not guaranteed. Most denials are not because your sibling relationship isn't real, they're because the proof is incomplete or inconsistent. The government wants clean documentation that you and your sibling share at least one parent. Usually that means birth certificates showing the same mother or father. But real life is messy. Some countries have missing or late registered birth certificates, name variations, different spellings, different dates, informal adoptions, step-sibling relationships, legitimation issues, and civil registry problems. If documents don't align, USCIS may ask for secondary evidence, baptismal records, school records, medical records, affidavits, and in some cases, DNA testing. DNA can be powerful, but it's also a process, a cost, and a delay. The key is not to wait for USCIS to demand what you already knew they'd question. Your job is to preempt. Another denial trigger is failing to prove the petitioner's citizenship. Only U.S. citizens can petition siblings. Green card holders cannot. There is no exception, and you must be at least 21 years old. People file too early or file under the wrong status and then wonder why USCIS rejects. The system is rigid. Now here's where the urgency comes in, because while you're trying to endure this 20-year backlog, Congress is debating whether sibling sponsorship should exist at all in future law. You've likely heard about recent House bills in early 2026 that included language about eliminating or restricting certain family categories and grandfathering petitions filed before the effective date. If a law like that passes, it's not the people who filed who lose first. It's the people who waited to file, which means if you're a U.S. citizen and you haven't filed for your sibling yet, waiting to see what happens is not neutral. It's a risk decision. Now let's get to what you really came for. How do you cut a 20-year wait down to something like 3 to 5 years without breaking the law? First, you need to understand the core strategic reality. The F4 line is a quota trap. You cannot expedite your way out of a quota trap. Humanitarian expedite requests do not create visa numbers. Congressional inquiries do not create visa numbers. Lawsuits do not create visa numbers. The line moves when numbers are available. Period. So the only real way to shorten the timeline is to leave the F4 lane without abandoning it. This is the strategy most families miss. Keep your F4 petition alive as a long-term backstop, but simultaneously explore independent pathways that your sibling may qualify for that are not chained to the F4 quota. And the biggest set of alternatives, when they're available, are employment-based pathways. Not because work is better than family, but because the employment-based system can, in certain categories, move faster and allow self-petitioning. Two categories you hear about a lot are EB-2 National Interest Waiver and EB-1A Extraordinary Ability. These are not fantasy visas for celebrities only. They are legal categories with evidence standards. Difficult, yes. Impossible, no. EB-2 NIW is for people whose work is in the national interest of the United States, who are well positioned to advance their proposed endeavor, and where waiving the job offer and labor certification would benefit the U.S. It can apply to researchers, engineers, healthcare professionals, entrepreneurs, educators, and many others depending on the endeavor and evidence. EB-1A is for individuals with extraordinary ability, sustained national or international acclaim. That standard is high, but many professionals underestimate their own profile. Publications, citations, awards, media, judging work, memberships, high salary relative to peers, original contributions, leadership roles. These are all evidence categories that, when assembled correctly, can create a viable EB-1A case. Now I'm going to close an open loop with a real-world style example, because this is where people finally understand the math. Imagine you filed an F4 petition, and you're 9 years into waiting, staring at another 13 years based on visa bulletin movement. If your sibling is a scientist, an engineer, a nurse with advanced credentials, a tech professional, a business owner with measurable impact, it's possible to build an employment-based petition that moves in 2 to 4 years depending on country, category, and backlog dynamics. That's not guaranteed, but it's possible. And the delta is life-changing. You're not saving time. You're reclaiming decades. Here's the catch. These cases are evidence wars. If you file a weak NIW or EB-1A, you can waste time and money. That's why you do a serious assessment first. Resume, degrees, work history, publications, projects, patents, awards, salary, leadership, letters of recommendation, and a clear proposed endeavor that aligns with U.S. interest. And here's another open loop. Employment categories also have country-specific backlogs sometimes, especially for India and China. So when I say 3 years, that is not a universal promise. It's a best-case outcome in certain categories and for certain chargeability. Which brings us to the little-known legal lever I promised earlier, the one many families never consider: cross-chargeability. In certain immigrant visa contexts, the country used for quota purposes can sometimes be based not on your sibling's country of birth alone, but on the spouse's country of birth. This is a technical area, and it depends on the category and the exact circumstances, but the principle is real. If your sibling is married to someone born in a country with a shorter backlog, that spouse's chargeability can sometimes be used to avoid the worst per-country delay. This is not a loophole you invent. It's built into visa allocation rules, and it is one of the only lawful ways the system allows a family to avoid being punished by birthplace if there is a qualifying marital connection. Not every case qualifies. Implementation can be complex, but for some families, it can shave years. Now, do not misunderstand me. I'm not telling anyone to marry for immigration. That's a crime. That's a permanent bar risk. I'm telling you that if your sibling is already legitimately married, the spouse's country of birth can sometimes change the chargeability calculation in ways that matter. This is exactly the kind of strategy you discuss with a competent immigration attorney, because a wrong assumption here can create catastrophic filing errors. Now, what about other, faster alternatives people whisper about, like bringing your sibling as a visitor and then adjusting status? Be careful. This is where families accidentally walk into fraud allegations. If someone enters the U.S. on a tourist visa with pre-formed intent to immigrate, that can be viewed as misrepresentation. Adjustment of status strategies require careful legal analysis and truthful intent. Don't take shortcuts because you're desperate. Desperation is what the system punishes hardest. What about student visas, work visas? Those can be legitimate pathways if your sibling actually qualifies. Admission to a program, financial ability, non-immigrant intent where required, employer sponsorship where applicable. They can get your sibling to the U.S. temporarily while the long-term immigrant path continues. But again, each category has its own rules, and violating them can destroy the very future you're trying to accelerate. Now, I want to bring this back to what you should do next, depending on where you are right now. If you have not filed the I-130 for your sibling and you are eligible, filing sooner is almost always better because your priority date is your place in line. Every month you delay is a month you give away. And if Congress ever changes the category, petitions filed before an effective date are often protected while future petitions are blocked. Filing early preserves optionality. If you already filed, do not abandon it. Treat it like a long-term asset. Monitor USCIS case status. Keep your address updated. Save every notice. When it is approved, save that approval. Then monitor the visa bulletin regularly. The line is slow, but it's still a line. Now the real strategy. Evaluate your sibling for parallel pathways. Start by collecting a professional portfolio. Resume, degrees, transcripts, licenses, employment letters, salary evidence, publications, awards, certifications, and any proof of impact. Then consult a qualified attorney to evaluate NIW, EB-1A, employer sponsorship, or other options. The consultation fee is trivial compared to the value of reclaiming 10 to 20 years. And while you wait, make sure you're not creating avoidable delays. File complete and accurate I-130s to reduce RFEs. Provide strong relationship evidence, both birth certificates, name change documents, adoption papers if relevant, divorce decrees if names changed, and any translations that meet USCIS standards. A sloppy filing doesn't just delay, it can create a permanent confusion in the record that later requires expensive correction. Now, let's close the earlier open loop about small mistakes that become huge. Here it is. The most common critical mistake in sibling cases is not paperwork, it's expectation management. People plan their lives around the idea that my sibling will be here in a few years. Then 7 years pass. Parents get older, emergencies happen, the sibling tries risky paths, someone uses a fake agent, someone makes a visa attempt that creates a misrepresentation record, and suddenly the family not only loses time, they create a permanent barrier. The correct mindset is this. F4 is a long, slow, bureaucratic channel. You keep it active. You don't emotionally depend on it for short-term solutions. You build parallel lawful options if possible, and you avoid risky shortcuts that can stain the record. Here's the reality I want you to leave with. The U.S. immigration system does not measure family love. It measures category, quota, and compliance. If you want to reunite with your sibling, you need strategy, not just patience. If you want a one-page summary, it's this. File the I-130 as early as you can. Keep it alive, watch the visa bulletin, and simultaneously investigate whether your sibling has an employment-based or other independent path. Consider cross-chargeability if it applies, avoid misrepresentation traps, and get real legal analysis before you spend years walking in the wrong direction. If this video clarified the truth behind the 8 to 22-year sibling backlog and gave you real levers instead of false hope, subscribe to Immigration News Desk. We track the policy shifts, the visa bulletin realities, and the hidden technical rules most people never learn until it's too late, and share this with one U.S. citizen who keeps saying, "I'll file next year," because in F4, next year can become next decade faster than you think. And remember, the system is slow by design. You can't change that overnight. But you can stop being surprised by it, and you can start making moves that put your family back in control.